Good afternoon, everyone. This is Mike Harrington. We're going to be beginning shortly. Thank you for joining us today. Hopefully everyone's dug out after yesterday's storm. We are going to be holding this session in listen-only mode. So if you do have a question, you can submit them under the questions box in your webinar tool bar, and we will answer them at the end of the presentation. Also, all of today's participants will receive an email from Jackie Rowe after the webinar with the PowerPoint presentation. Feel free to share that with coworkers or colleagues, and an attendance certificate. As always, we'll circulate a survey, and we appreciate any feedback, not only about today's seminar, but if you have any questions or suggestions for topics for the future, we would appreciate it. Okay, so why don't we get started? Today we're going to be talking about transgender employees, and certainly this is a very hot topic. The Supreme Court has taken up a case and will be weighing in on this topic probably in its next term. It will be interesting to see whether there will be a full bench or whether the court will remain with only 8 members at the time the case is heard, but we will get to that shortly. In beginning our conversation, I think it's important to have a sense of vocabulary. And some of these terms may be familiar to you or may not, but let's walk through them. So gender identity addresses a person's internal sense of whether they're male, female, or some combination thereof. Gender expression relates to how a person represents or expresses their identity, either through clothing, behavior, lifestyle, body characteristics. Gender nonconforming is when someone's gender expression is different from societal expectations. And this is going to be an important aspect or idea when we get to how the courts have dealt with discrimination claims based on gender identity or claims brought by a transgender individual. Non-binary simply represents the idea that someone may not identify directly with either male or female. Now, transgender is a broad term which relates to people whose identity, expression, or behavior is different from those typically associated with their assigned sex at birth. What's important to recognize is gender expression and identity are separate concepts. Someone may identify with a certain gender, but they may express themselves in a way that's more traditionally associated with a different gender. Transgender man is the term referred to a transgender person who is identifying as a man, regardless of that person's biology. And a transgender woman is the term for a transgender person who is identifying as a female. What's important to recognize is both state and federal law prohibit discrimination or harassment based on an individual's sex. And when we look at some of the cases that have come out, they have focused on whether transgender individuals or discrimination against a transgender individual satisfies the legal threshold of sex and therefore would allow a court to determine whether there's been discrimination or not. State law, including Connecticut and Massachusetts, not only protect an individual's discrimination or harassment based on an individual's sex, but also sexual orientation, which is inclusive also of sexual identity. So under state law, it's very clear that any discrimination that occurs on the basis of someone being transgender or expressing themselves in a certain way which may or may not conform to social norms would be an impermissible basis for taking an employment action. I want to just walk through a couple cases that I thought really highlighted some of these issues and sort of sensitized us to what is going on. The first one is the case that actually the Supreme Court has granted cert on last October and will likely be addressed in the next court term. So not in this court term that's going to end this June, but the following court term. And so it is likely that a Supreme Court justice will be added to the court by that time. But this case is a Title IX case, and even though employment considers Title VII of the Civil Rights Act, Title IX concerns educational institutions, the concepts are really identical. And here you had a situation where, and this was out of the state of Virginia, Virginia had directed that a transgender male who had female anatomy but identified as a male could not use the boys' restroom. And they did make a gender-neutral restroom available. And it'll be interesting to see how the court addresses this issue, because at one level, this court concerns the power of the U.S. Department of Education to interpret its own regulations. And their regulations say that schools may distinguish restroom and locker facilities on the basis of sex. And the question is, how is that to be interpreted? The department interpreted that you have to allow a person, based on their gender identity, to use the bathroom that matches their identity as opposed to their biology. And so the Fourth Circuit Court of Appeals, which governs cases out of Virginia, did affirm or strike down that the school board could not prohibit this student from using the boys' restroom. And that's what's up on appeal. So it'll be interesting to see whether the court addresses this in a very narrow fashion, in terms of simply saying the Department of Education gets to decide how to interpret its regulation, or whether it takes a broader view of the case and speaks as to the civil rights that individuals may have who are transgendered. Obviously, with the election and the new appointment of a cabinet member for the Department of Education, this case could take some different turns, but we'll have to see how it plays out. So this is definitely one that employers will want to be looking at, even though it's being brought under Title IX. And we're going to talk a little bit later in the presentation about restrooms and locker rooms and some of the challenges they present. So we'll be looping back to this shortly. One of the other cases that I wanted to bring to your attention was out of the 11th Circuit. What's interesting is all the circuits who have addressed this issue have found that it is impermissible to discriminate on the basis of transgender status. And so employers now need to be sensitive to the idea that I think it's pretty well established that this is going to be a protected classification under state and federal law. This case speaks to, again, what might occur in a subtle manner, is where people feel that someone doesn't fit into a group because they are not acting in a way that matches society's expectations of how the different genders are to conform. And this case reminds us that that is an impermissible basis for making an employment decision. In Smith versus City of Salem, you had a classic case of blatant discrimination where a plaintiff was suspended based on sex after he began to express more feminine appearance and notified his employer that he was planning to undergo a physical transformation from male to female. Again, the only reason the employer acted in that particular case was because of being notified that the individual was going to be transitioning from male to female, and also began to act in a way consistent with that individual's identity as a female. Completely impermissible basis for making an employment decision. Here we have another recent case involving out of the Sixth Circuit, again dealing with sexual stereotypes and expectations of how people may be thought to act or not. And here you had a police officer who, off-duty, was living as a woman, identifying as a woman, and then was being harassed because of that. So you have both a combination in this case of an individual's private conduct, off-duty, and now coming into the workplace and creating disruption and generating the foundation for a harassment complaint. Again, this reminds employers that if they see people being harassed, even if it relates to issues that occur outside the workplace, the employer is going to have an obligation to address those issues if they are coming into the workplace. And interesting, I thought this case was worth mentioning. This is out of the First Circuit, which governs Massachusetts, Vermont, Puerto Rico, and Maine, that, even declining to provide services to an individual because of their transgendered status is going to create discrimination issues for that business. And in this particular case, the business was alleged to have denied a loan to the transgendered plaintiff, and that was found to be discriminatory. So I think what we can take from these cases is that the law is fairly well settled, that transgender status is a protected status, and that basing an employment decision or basing the provision of services or the refusal to provide services to an individual based on their status as a transgender individual will form the basis of a discrimination claim. So that part, I think, is established. I think the more uncertain area that we need to monitor, or uncertain to certain aspects, I should say, is what makes for a harassment claim brought by a transgender individual. Now, and the reason why I say this is a little gray is these forms of discrimination, I think, can be very subtle. Certainly, some forms of harassment can be very explicit and severe and obviously need to be addressed immediately. There's other forms of harassment, which we're going to talk about, that I think are more subtle, and human resources has to be very vigilant in making sure they make themselves available to listening to any concerns brought by a transgender employee and then being responsive. And one of the ways that has come up in a number of cases that might be subtle is around the concept of the individual's name and how they would be like to be referred to. Obviously, there are certain documents, employment documents, that require individuals to use their legal name. For example, a W-2 form, maybe certain retirement forms need to have the individual's legal name used on the document. But there's a whole other area of documents or situations where an individual's legal name is not necessary. For example, business cards. And so when an employer, and there have been several cases that have involved this kind of concern where employers have refused to allow an individual to use a name that reflects their decision to transition, or reflects a gender identity that's different from their biology, that has been the basis of a harassment claim. So just as you would allow, I'm sure, most people would allow business cards to say Chuck Smith for an individual whose formal name is Charles Smith, if there is an individual who, used to be known as Samuel and now wants to be known as Samantha, the employer should not be refusing to provide business cards reflecting that desired name. Similarly, there's been some cases and activity around email names. Some employers, if you have this luxury, simply have gone with simply the first initial and the individual's last name. Those tend to present less issues for the employer, where the individual's first name is reflected in the email address, and there's a request to change that based on how the individual is now identifying. An employer would be wise to allow that and not to refuse to do so. Same thing with if people have either cubicle or names on their offices, those should be allowed to be named. And the other form of harassment that there's a fair amount of cases that deal with is people using the individual's former name or former a pronoun reflecting their former gender identification. And if that happens once or twice because the individual was so conditioned, that might be one thing. But there are a number of cases now that have been filed where it is clear that the individuals are deliberately using the wrong name or wrong gender pronoun. And that's where HR really has to be stepping in and taking concerted activity in addressing the individuals who do that, because that will, over time, create a hostile work environment that then may create liability for the employer. In this area, the cases to date do reflect the idea that religious objections to gender transition are not a defense to harassment. Simply because someone's religion does not acknowledge transgender individuals, or the idea that someone may identify with a gender that is not of their biology is fine. They have the right to that opinion. What they do not have a right to do in the workplace is conduct themselves in a way that creates a hostile workplace for their coworker. And they need to be told that they can certainly hold whatever opinions they have, but when they come to work, they need to comport themselves in a civil manner that does not create a hostile workplace for their coworkers. And if they cannot comport to that mandate, then they are not qualified to work in the workplace. So this is another area that HR may need to step in. Now let's get to restrooms, because I know this is a topic that a lot of people have been talking about. Obviously, this is the context that the Supreme Court is going to be hearing about this case. And I just wanted to first acknowledge where the two federal agencies have already gone on record. In addition to the U.S. Department of Education in interpreting its Title IX mandate, the Equal Employment Opportunity Commission and OSHA have made it clear that they believe their regulations require employers to allow employees to use the restroom of the gender they identify with. What's been interesting is some of the dialogue and commentary in this area reflect discussions about restrooms and less discussion about locker rooms. And I think that will be an interesting area for a court to explore when the right case is presented. And by the way, the case in front of the Supreme Court, the policy coming out of the local school board did deal with both restrooms and locker rooms. Because obviously in restrooms, there's generally some level of privacy that can be provided to users of the restrooms in whatever gender-specific bathroom they might use. In a locker room where people are disrobing and maybe showering, not so much. So it'll be interesting to see if there is a distinction made between restrooms and locker rooms or not. But both the EOC and OSHA have been clear about their guidelines. OSHA's guideline stems from a very old standard, which is a mandate that employers have to provide toilet facilities within a reasonable distance from where an individual is working. And the idea that an individual cannot use a restroom of the gender they identify with, in OSHA's view, equates to a denial of access to an appropriate restroom. The New York Times, when they were addressing this Supreme Court case that will be heard, the Grimm case, one of the things noted in the brief is that the student at issue, because he felt he could not use the boys' restroom, which is the gender he identified with, he would abstain from drinking any liquids so that he did not need to use a rest facility, and that subsequently caused him to have some urinary infections. So I think we're going to see this definitely present itself in a different way when that kind of testimony is offered. It's also interesting, in the case of Grimm, the student was allowed to use a gender-neutral restroom. And in his brief to petition the Supreme Court for certification, his lawyers presented the idea that he felt that using that private gender-neutral bathroom was humiliating. Some courts, I would imagine, are going to find that if that type of compromise or facility is made available, that they would find that adequate, and other courts may not. I think that's one of the areas we're going to have to wait and see how this plays out. One thing employers who do have gender-neutral restrooms at least can do is, depending on what the exact situation is, and I think a lot's going to depend on the particular facts of a case as they present themselves, is offer a gender-neutral bathroom to a transgender individual. If they do not, if they're not satisfied with that offer, you may have to make the decision of whether to allow them to use the bathroom of the gender they identify with. If there are employees who feel uncomfortable with that, with sharing the bathroom with that individual, then they can choose to use the gender-neutral facility. For those employers who only have facilities for men and for women, those options aren't available. But we'll have to see how it all plays out. At this point, there's been no definitive case other than the Grimm case dealing with restrooms and with the EOC or OSHA guidelines. So we'll have to wait for that. Now, based on some of the cases and some of the literature, I think HR has several best practices that they can adopt in this area to minimize any legal exposure, starting with making sure not only the employer but all of the employees use the name and gender pronoun desired by an employee. Also, in that same regard, is respecting the transgender employee's privacy. Part of this is recognizing that people may find it difficult to be public about their transitioning, and they are the ones that get to set the timetable for how they want to disclose their transition. There may be individuals who want, have no problem with a, sort of a very rapid disclosure. Other employees may wish to do it very gradually. And simply because you see an employee beginning to take steps to maybe transition and reflect their new gender identification, that does not give the employer license to be presumptive and make some public announcement. It may be the case that you have an employee who had been identifying as a male who then begins to dress in a more feminine manner or wear more feminine jewelry. It is not the role of the employer to make any inquiry of that individual so long as they are performing the essential functions of their job, and really should just allow the employee to disclose any information at their rate or at their pace. Interestingly, there's been several articles I've read from individuals who have transitioned, and they recognize that sometimes people with the best of intentions create very awkward situations for them. One individual wrote that they were transitioning from male to female, and there were several coworkers who, again, with what she perceived as good intent, were very quick to offer fashion advice and makeup advice. But that advice was not welcome or solicited. So you may need to remind employees that, even though they may wish to be helpful, that unless their assistance is asked for, they really should refrain. Okay. So other things HR can do and should do. In this time, I think it would be a good occasion to make sure all of the benefits that the employer offer do not either indirectly or directly discriminate against individuals who are transitioning. You might also want to look at your anti-discrimination policies and make sure they include references to transitioning or transgender individuals as a form of a protected class. And when you do your trainings now, and certainly this is something we've been doing for a number of years now, in Connecticut there's a mandate to train supervisors about preventing sexual harassment. We have taken that as an opportunity to also train people on not to harass based on other protected classifications such as race, disability, and this would be a good time to include training based on transgender status, and to ensure that your employees are at least aware of ways to prevent engaging in any potentially harassing conduct. Another thing that might come into play if you have a transgender employee is having to modify either dress or grooming standards. You might have to purchase uniforms, if your workplace requires those, of different sizes than you've had in the past. And again, you want to take any steps you can to make sure you are not treating an individual who is transgender differently because of his or her transgender status. So what not to do? These are sort of the opposite side of the coin. Don't make any assumptions that simply because someone's transgendered, that it means they either gay or not. Really, they are very different concepts and very individually specific. And really, an employer has no business becoming or inquiring into someone's sexual identity or sexual orientation, but really only needs to ensure that that individual is capable of and in fact performing the essential job functions of the position they occupy. You don't want to do things like ask someone what their real name is. You don't want to provide unsolicited advice or ask personal questions. Really, to the extent you can, continue to be objective in the individual's performance of their job and evaluate them as you would any other individual performing that job. Okay, that's it for now. Let's see if we have any questions. Just one moment.
There's one right now.
Okay, we do not seem to have any questions at the moment. We'll stay on the line for just a few minutes to see if there are. As cases come out, and certainly we'll be closely monitoring this Supreme Court decision, there may be some additional guidance provided to employers. Okay. So one of the questions was, will this presentation be emailed? Yes. At the end of this presentation, you will receive an email from Jackie Rowe, which will include this presentation. If for whatever reason you don't receive it, please let us know. Another person asked, how will EOC questionnaires change in the future? I think that's a really good question. I think it's really uncertain for a lot of different reasons. One being we have an administration occupying the White House that I think has a very different perspective on this topic than the prior administration. So I really don't know what to think what will happen with regard to the EOC questionnaires, whether they will continue to just have a binary view of the world, male or female, or whether they will begin to incorporate any recognition that there are people who don't always identify with one or the other. But I think that is an interesting area we will want to monitor and keep abreast of. Okay. If there are no other questions, we are going to be doing another seminar. We're working on a topic right now in the second week of March on Friday. So please join us again and look for the announcement. We'll be deciding shortly what the topic will be. If you have any topics that you would like us to consider presenting on, drop me or Jackie Rowe an email this afternoon. And we would be glad to present on a topic that's of interest. We appreciate your time and hope you have a good weekend. Thanks.